So, welcome to our webinar today on laws that strengthen code enforcement procedures and expand habitability standards for renters in the private rental market. My name is Neda Hussein, and I work at the National Low Income Housing Coalition on our research team as a state and local research analyst. I'm really excited that you all could join us today. Our call will focus on state and local advocacy to enact code enforcement procedures and expand habitability standards for renters. I looked over at the chat and saw a question, will your presentation be shared with attendees? Yes, we will have this go out in our memo to members on Monday, and we will also share it in our connection this Friday. We'll share a recording of this webinar and we'll share this large slide deck as well. So next slide, please, Tiara. Perfect. So we have a wonderful agenda planned for you all today. As I mentioned, we'll hear from state and local advocates on efforts to enact these protections for renters. We are joined today by Spencer Bailey from Colorado, who will share about House Bill 24094, which was passed in 2024. He is joining us from the Community Economic Defense Project. To talk about the state level advocacy that went into passing that stronger habitability law last year. And then we'll shift over for a local level spotlight and talk about New Orleans and efforts to pass the Healthy Homes Ordinance in 2022. Phase one of the ordinance went into effect last year or this year, I believe.
Pleasure.
Monique and Andrea and Nico will share more and correct me if I'm wrong, but Monique Blossom, Director of Policy and Communications at the Louisiana Fair Housing Action Center, will be joining us, and Andrea Nika Morris, Executive Director at HousingNOLA, will also talk about the efforts to enact this protection in New Orleans. So we will save Q&A until the very end, but at any point during this webinar, please feel free to put your questions in the chat or use the Q&A function, and we will get to it. And if we are unable to get to your question today, we will share our contact information. That way you can connect with us offline. And if we are unable to answer it, we will try our best to connect you to someone who probably has the right answer. So thank you all again. I'll probably say thank you many, many times during this webinar. But next slide, please, Tiara. All right. So this webinar series formally launched in the fall of 2024 um, with with four webinars taking place in this series. So the Strengthening Renters' Rights Primer on State and Local Level Tenant Protections webinar series. Today is our final webinar in this series. We first launched in the fall of 2024 with a call on laws that limit excessive rental fees, which are commonly known as junk fees. Um, for those who signed up for this webinar series, you probably recall that in February, we hosted a call on just cause eviction standards, and then in April, we hosted a call on rent stabilization protections. Next slide, please. I want to shout out our presenters and panelists who joined these webinars over the course of the few months that we had these take place. They I want to thank them for sharing their expertise, their insight, and their overall knowledge about the protections that we presented on over the course of this webinar series. Thank you all so much. Many are here today on this call or maybe in the audience, but I really, really appreciate you and taking the time to speak on our webinars. Next slide, please, Tiara. Um, these webinars were meant to highlight a set of toolkits and case studies that we released in the fall of last year. As you may know, if you joined one of these webinars before, in which I talked about these toolkits, they are meant to highlight a number of state and local level tenant protections that can be passed to strengthen renters' rights. Our four toolkits, I should say, that we focused on include just cause eviction protections, rent stabilization protections, laws that strengthen code enforcement procedures, which we are focusing on today, and laws that limit junk fees in the private rental market. These toolkits are meant to provide a basic overview of each of the four protections and to share more information on the core components of each of these protections. We also include information on states and localities that have implemented and are enforcing these protections currently. And then we also offer recommendations from tenant advocates on how these laws can be strengthened to cover the greatest number of renters and provide the greatest support as well. Um, just because this is the final webinar in this series doesn't mean that we have to stop the conversation on state and local level tenant protections, and we definitely will not. We are also hoping to maybe continue the series in the fall. So I would love to hear in the chat if there are any protections that you would be most interested in hearing about. Or learning more about. Um, so if you would like to please put in the chat any protections that are of most interest to either you or your organization. And I see in the chat that in Chicago there are efforts now to pass a just cause ordinance. Yes, I am aware, and we are really excited for that, and are keeping our fingers crossed that just cause, which includes a provision on relocation assistance and a rental registry as well, will pass in Chicago this year. There are some good suggestions in the chat. I see source of income. Oh, and there is also a question in the chat. Can I get a copy of all four of these? We will post a link to the toolkits in the chat. But I do want to note that we do have recordings of these webinars. I can include them in the write-up that I do on this webinar in our connection and in our memo as well. That way you all can access them after this ends. And there are some great comments in the chat. All right, I'll keep reading them, but next slide, please, Tira. All right. So as I mentioned, we also released case studies in addition to the toolkits that we released last fall. And the purpose of the case studies was to provide sort of a deep dive into the protections that we mentioned in the toolkits. While our toolkits are more technical in nature, the case studies are meant to highlight the qualitative impact of these protections. So in the case studies, we highlighted a habitability law passed in Cincinnati, and then we highlighted New Orleans as well. And Monique and Andronica will talk about the New Orleans case study today. The purpose of the case studies, and we released our habitability case study in November of last year, is just to provide an overview of how these protections were won, the advocacy campaigns that occurred to ensure the successful passage of these protections, and then how they are currently being implemented and enforced. Next slide, please. Perfect. And we decided to focus on those four main protections, just to give an overview of sort of the broad array of protections that exist for tenants at the state and local level, but that is in no way the only protections that exist for renters. In January 2021, our team at the coalition launched a state and local tenant protections database. The purpose of the database in 2021 was to provide an overview of the protections that existed in conjunction with the emergency rental assistance funds allocated by the federal government. But we also included information on short-term protections that existed to protect tenants against the impact of the COVID-19 pandemic. In May 2023, we expanded our database to include protections passed across all years and all localities. And we include a number of categories in our database. This includes rent stabilization protections, just cause eviction standards, right to counsel, eviction record sealing and expungement, source of income, and many more. This picture is a little outdated, I will say. There are more than 719 protections included in our database, tracked across all 50 states, and we also include information on more than 200 localities that have protections in place currently. For our database as well, you will also find information on preemption policies that have been passed at the state level. This includes preemptions on rent control, source of income protections, or for advocates in Florida and Texas, you may know of the preemption policies passed to attack a number of renters' rights across the state. Um, and Sarah is doing amazing work posting in the chat some of the resources that we have. She posted our tenant protections database if you would like to learn more about the protections we have included. There's also a form embedded on the website as well. If you don't see a protection that maybe exists in your state or locality, you can let us know and we will be sure to include it in there. Next slide, please, Tiara. All right, so to start talking about laws that expand code enforcement procedures and help to ensure their effective enforcement and proactive enforcement, I should say, it's first important to understand how we define these types of protections from the coalition side, especially as we have it written in our toolkit. So when we talk about laws that strengthen code enforcement procedures and habitability standards, we're not just talking about states that have an implied warranty of habitability. We are talking about laws that go even further than that. This includes ensuring that these laws have the necessary mechanisms in place to ensure that these laws are proactively enforced, and that tenants have rights in place to protect themselves against health and safety hazards that are probably occurring in their own unit as well. So there are four ways and four key points that I really want to touch on as to how we define these laws. And that includes that tenants have access to information related to their rights under the law, so that if a habitability issue is present, tenants know where they can go or what rights exist for them to report a habitability concern. Second, there are explicit prohibitions on landlord retaliation against tenants for reporting concerns related to housing, health, and safety. Um, this includes that tenants will not be retaliated against if they speak out against a habitability concern or if they make the necessary department aware of a concern that might be present in a rental unit. In New Orleans law, you'll note that there is a retaliation provision embedded into the law. And then third, we have the proactive enforcement or ensuring that there are the necessary resources in place so that tenants have, or I should say tenants are able to access the law in the way that it was written. And then four, there is an expansion of the housing conditions covered under a jurisdiction's warranty of habitability. This includes making sure that the types of habitability concerns that a tenant might experience are covered under the law. This could include the presence of mold, faulty housing structures, amenities that are not working or not available to tenants, and many more. And next slide, please, Tiara. Thank you. So in addition to defining what these laws actually are, it's important to understand why they are so important to tenants and to renters across the country. There are two main points that I want to touch on. First is that housing is connected to every aspect of life, and when housing has health and safety hazards present in a unit, this can significantly impact mental and physical well-being. Um, the presence of habitability concerns can cause chronic illnesses, and even death for tenants. And access to safe, stable, and affordable housing is a right that should be afforded to tenants all across the country. And when there is not proactive enforcement of these laws, it can mean that tenants have habitability concerns that go unchecked for very long periods of time. And second, the point I want to touch on is that when these laws are in place, it ensures that there are ways that tenants can access their rights and ensure that um, any habitability concerns are rectified in a timely manner. I really want to point to this survey conducted by the Joint Center of Housing Studies at Harvard, who released a survey in 2021 to say that 2 in 5 renters do not believe that landlords would address negative health impacts in their home. And the point I really wanted to make is that when these laws are in place and when tenants have access to these rights, we can ensure that any unchecked habitability concerns are are answered in a timely manner, as I pointed out. Next slide, please, Tara. All right. And going a little bit deeper into that, just to talk about who is most impacted by habitability concerns in rental housing. As you can see from this study conducted by the United Health Foundation in 2024, over a 5-year period between 2017 and 2021, it was found that housing habitability concerns are not felt equally across population groups. And we will share these slides out after this call, as I mentioned, if you would like to take a look at how habitability concerns are um, felt across different population groups. Next slide, please, here. All right. So when we talk about the proactive enforcement of these types of laws, there are many ways that housing advocates and legislators and lawmakers can take action to protect renters against health and safety risks that are present. And this can be done in a number of ways. So this includes rental inspection programs that can be passed, requiring that landlords apply for a license to rent. Or submit to a rental registry. This could include a city or locality creating an emergency repair fund for tenants to access funds to fix a habitability concern. This could also include hiring additional code enforcement officers to help with capacity issues. And this could also include creating agencies to oversee habitability complaints from tenants. And also this goes with the capacity piece to just ensure that there is a proactive enforcement of code enforcement procedures within a state or a locality. And next slide, please. All right, so in our tracking, in our database, we have tracked these protections across more than 11 states and 12 localities nationwide. And just to note again, this does not include the implied warranty of habitability, but more so includes additional protections that are passed on top of those laws to strengthen renters' rights across the array of protections that I mentioned on the slide before this. In 2025, I'll note that at the local level, Montgomery County, Maryland, and Albuquerque, New Mexico, both advanced stronger habitability protections for tenants, and we can post those in the chat in a minute. But just to note that if there are additional protections that you're aware of in your locality or in your state, please flag it for me. I will post my contact information at the end of the slide deck. But if anything comes to mind now and you want to post it in the chat, feel free to let me know. Next slide, please, Tara. All right. So in our toolkits as well, we also analyze the core components of this type of legislation. Going back to our tracking, we looked at states and localities that have these protections in place, and sort of extracted the core components of what typically goes into these laws when they are being passed at the state and local level. So there are four key ones, and we'll post the toolkit, or I should say Sarah did post the toolkit if you would like to read it more in depth. But the four key components are: one, including a definition of habitability and an explanation of the duties of landlords to maintain a habitable premises. Second, to include information about notices and timeframes for landlords to remedy housing violations. Three, the mechanisms for enforcing landlord compliance, as well as including any violations that are levied against landlords for not complying with the law. And then four, any anti-retaliation protections for tenants who report a housing issue and are at risk of eviction or harassment or discrimination by their landlord. So next slide, please, Tiara. All right, and finally, if you would like to reach out to me, I have my email posted on the screen, but I will also drop it in the chat if it's easier to copy that way. But I look forward to hearing more about maybe your work at the state and local level to expand code enforcement protections. And if there are any protections that our database is missing, please also let me know. Next slide, please. All right, so I want to pass it over to Spencer Bailey, who will join us to talk about Colorado's updated warranty of habitability. Spencer, thank you so much for joining us, and I will pass it over to you.
Awesome. Thanks for the invite. So hey everyone, I'm Spencer Bailey. I am an appellate attorney at CED Law, which is the law firm of the Community Economic Defense Project in Denver, Colorado. And I'm going to be talking about Colorado's updated warranty of habitability statute. Next slide, please. So as I mentioned, the Community Economic Defense Project is where I work, and we partner with low-income and working people to build economic and racial equity. And then the law firm that I'm a part of is sort of the legal wing of the Community Economic Defense Project. And we do all sorts of things, including eviction defense, affirmative litigation against landlords, and then also advocate for policy changes at the state and local level. Next slide, please. So today I'm going to talk about Colorado's warranty of habitability statute. I'm sure I'm going to get that word wrong several times as I try to pronounce it. And then how we updated it through the state legislature with Senate Bill 2494. And then I'm going to talk a little bit about a Denver ordinance that was inspired by Senate Bill 94. Next slide, please. Next slide, please. So here's a little bit of background on Colorado's warranty of habitability. Our state, Colorado, was one of the last states to enact a warranty of habitability statute. I think it was either the 48th or 49th state. And the original 2008 statute was very weak. It had a lot of gaps. It was very pro-landlord. It had several presumptions in favor of the landlord. It had very onerous notice requirements. It gave landlords essentially a open-ended timeline to make repairs, and gave very little teeth for tenants to enforce its requirements. So the state legislature made some changes in 2019 that increased protections for tenants, but that effort still left some gaps and then had some unintended consequences that I'll talk about in a minute. Next slide, please. So I'm going to go into some of those updates that were necessary after the 2019 bill. And those came in Senate Bill 2494, which was called Safe Housing for Residential Tenants. And it went into effect last May. So we've had it for just a little bit over a year. And I can talk a little bit about how the changes that were made through Senate Bill 94 have had an impact on tenants in Colorado. Next slide, please. So here's a little bit of background on Senate Bill 2494. Prior to this bill, our state's warranty of habitability statute had a lot of problems. One of the main ones is that it only required landlords to start repairs after they got notice of an uninhabitable condition in a tenant's home. And so landlords could very easily use this to say, well, we sent an inspector over, so we started repairs, and then drag their feet on actually making the repairs and finishing the repairs. And so this was a very large loophole that landlords, some of the bad actor landlords, would take advantage of in order to say that they were in compliance with the warranty of habitability. Excuse me. The statute also had some unenforceable requirements that landlords widely ignored. It had complicated written notice requirements for tenants, and I'll go into some of those here in a little bit. Many sections were confusing or ambiguous, and it kind of was unclear when this requirement kicked in and there was always, these questions and doubts as to whether or not a landlord was in compliance or whether or not they had more time to comply. It also gave landlords this easy escape under a broad casualty or catastrophe exception that essentially said the landlord can terminate a tenant's lease if there was a casualty or catastrophe. And we would frequently see landlords saying, oh, well, there's a lot of mold, or, oh, there was a leak in the roof. We're going to declare it a casualty or catastrophe and just terminate the tenant's lease, rather than make repairs so that the tenant has a habitable home. And that led to tenants being very scared to make requests or to really advocate for their rights, because they were worried the landlord would just terminate their lease under this casualty or catastrophe exception. It also allowed landlords to basically not maintain any maintenance records. And so when a tenant would try to enforce their rights, and maybe they were in court for an eviction, or maybe the tenant brought their own lawsuit, the landlord would just say, oh, well, we don't keep anything past 30 days. And so there's essentially no evidence that the tenant gave notice or when the landlord knew about certain things. And it really kind of when the burden was on the tenant to prove that the landlord had violated the warranty of habitability, it made it very difficult for the tenant to prevail. And then lastly, the tenant remedies were very complicated and confusing, would have all these different changing timelines and notice requirements, and then second notice requirements. And it was all very confusing. Some of the notice requirements required to have like specific language that tenants had no idea they needed to include. And so those were very difficult for tenants. And, it was a common advice from tenant attorneys to say, don't try to use any of the remedies in the warranty of habitability without talking to a lawyer first, because you're probably going to mess it up. You're not going to get it right. And then it ends up backfiring on the tenant. And that was very frustrating, because we wanted to see a warranty of habitability that tenants could use on their own without needing to turn to legal assistance. Next slide, please. Then there was sort of a sea change in 2023 with a Colorado Court of Appeals decision called Anderson versus Shorter Arms. It was the first decision on Colorado's warranty of habitability that was published by the Court of Appeals, and it was bad for tenants. It essentially required strict compliance with the detailed written notice requirements in the statute. And so in that case, one of the requirements was that a tenant would have to provide permission for the landlord to enter the unit along with their notice of the uninhabitable condition. And that was very, not commonly followed, because tenants would think, well, if I told the landlord that my heater is broken, or that there's, the toilet is broken, or that there's mold everywhere, isn't that implied permission to come in and make the repair? And the court said, no, the notice has to explicitly give written permission for for the landlord to enter, even in cases when no entry into the unit was actually needed. Maybe the heater was broken because the boiler down in the basement was broken, and the landlord actually never needed to enter the tenant's apartment. Still, the tenant would have to provide permission for the tenant to enter. So it was this very strict technical requirement that very few tenants without legal assistance, realized they needed to include. It also allowed landlords to mislead tenants by letting landlords say, oh, if you have a problem, just give me a call or come down to the office and talk to our people, resulting in the tenant not actually giving written notice about the uninhabitable condition. And then the landlord could say, oh, the tenant didn't follow the warranty of habitability, so there is no breach and they have no claim for a violation. So this Court of Appeals decision really coalesced and inspired the tenant advocates and the various nonprofits that support tenants to come together and say, we need to make a change because the 2019 bill didn't do enough to increase protections for tenants. Next slide, please. So this was the coalition that came together to try to advocate for Senate Bill 2494. The organization I work for, Community Economic Defense Project, was part of leading that effort, as well as the Colorado Poverty Law Project and the Denver Foundation. And we really were happy to have the Denver Foundation on board because the other two organizations, mine and the Colorado Poverty Law Project, are legal nonprofits that represent tenants in eviction disputes. And so, having another coalition partner to come in and say, no, this isn't about, lawyers trying to win in court, which is how opponents often would frame pro-tenant bills. Instead, it's about this larger issue that's impacting entire communities. And we also had supporting organizations as part of the coalition that I have listed there below. And it kind of shows that we were able to kind of pitch this bill as something that crossed all types of issues, related to communities, related to public health, related to code enforcement, related to tenants' rights. And also, a lot of parts of the warranty of habitability at the time were unclear to landlords. And so we also could say we need to clear it up for landlords to know what they need to do in order to comply, because there's these areas that are very unclear. Next slide, please. So some of the updates that the Senate Bill 2494 made to the warranty of habitability is that it, lessened some of those notice requirements on tenants. It required landlords to both start, continue, and finish repairs, which, it seems very obvious, but, we had many landlord attorneys happily point out that the old warranty of habitability only required them to start repairs and never gave them a timeline to finish the repairs. It created several presumptions that put the burden on landlords to prove compliance. And that was because oftentimes, whether or not a landlord has complied with the warranty of habitability, the evidence or the proof of that would be in the landlord's possession. Whether or not the landlord has called a plumber, whether or not they've scheduled the plumber, whether or not they paid the plumber, whether or not they ordered the broken part, all of that is in the landlord's knowledge and control. And so it was often very difficult for tenants to know, what has the landlord done? How do I know if they've breached the warranty of habitability? How do I know if they're doing anything to come and fix this thing in my home? And so we made sure that the bill included these presumptions that put the burden on the landlord to show, this is what we've done to comply with the warranty of habitability and make sure that, the tenant's home is being repaired in a timely manner. It also streamlined some tenant remedies. It created some enforcement of certain requirements where there was no enforcement, particularly around the landlord communicating to a tenant, hey, this is when we're coming to make repairs. This is the expected timeline to make repairs. It strengthened protections against retaliation and organizing. It also required a hotel or alternative unit during major repairs, and particularly making sure that that wasn't something that landlords could use if they were kind of upset with the tenant and say, well, then I'm going to put you in a hotel that's like, on the other side of town, or I'm going to put a family of 6 in a hotel that's only got 1 bed. We added in some details that said you can't do that. It has to be fair. It has to be kind of treating the tenant in a way where, they're not being retaliated against just because there are major repairs that are needed in their home. So it got rid of the casualty or catastrophe loophole. It required landlords to repair air conditioning units, and it also allowed attorney general enforcement. Next slide, please. So so these are some of the remedies that the Senate Bill 94 updated in the warranty of habitability. And the main one that I would want to point out is that we made it a lot easier for tenants to raise breach of the warranty of habitability as an affirmative defense to an eviction without needing to pay a bond. Under the original law, there was this very heavy and expensive bond requirement. And then under the 2019 law, they lessened that burden, but it still was a very complicated waiver process that the tenant would have to go through in order to get the bond waived. And oftentimes, if a tenant didn't have didn't have an attorney assisting them, they didn't realize they needed to ask the court for a waiver of the warranty of habitability bond, and then the courts would, unfortunately, very happily strike the warranty of habitability defense, which then made the case a lot easier for the judge to decide. So we got rid of the bond requirement. We also included a much easier and simple process for tenants to go to court and get a court order requiring that the landlord make repairs or to put the tenant up in a hotel. And we've seen some tenants successfully do this on their own without needing an attorney, because we've created forms that are very simple and straightforward that a tenant can easily fill out and submit to the court. And then we also put in some presumptive fair rental values. So if a tenant's home has some severe or emergency conditions in their home, and the statute lists some examples of what those will be, then there's a presumed 100% reduction in rent. And if it's anything else, then there's a presumed 50% reduction in rent. And the burden is on the landlord to prove that the value of the apartment or the home is greater than one of the 50% reduction or the 100% reduction. Next slide, please. So I'm going to talk a little bit about getting Senate Bill 94 passed in the legislature. And these are just some of the main things that jumped out to me while I was thinking about this and reflecting on our efforts to get it passed. And again, this is just from my perspective, but some of the main features of it getting passed in the legislature is that we had very strong bill sponsors who were very passionate about the bill, who really wanted to understand it and wanted to be able to go toe to toe with their colleagues in the legislature, explaining why it was necessary. As I mentioned further down, one of the biggest challenges that we faced and that some of our sponsors faced was this question of do we really need this? Didn't we fix this in 2019? Why is there another bill coming around, 5 years later to do another pass on the warranty of habitability? I thought this was already taken care of back in 2019. And so we had great bill sponsors that really wanted to understand and be able to in detail explain why this bill was necessary. And then we also had a very strong coalition that it went beyond just sort of the tenants' rights group, but also included organizations that were concerned about children's health, concerned about public health. We had some environmental groups that wanted to come in and talk about the air conditioning requirements. And so we kind of really pulled in all these different interests and understanding how they could overlap. And then there was lots of education for the elected officials. So as I said earlier, Anderson versus Shorter Arms was that Court of Appeals case that was very bad for tenants. And we heard several times some legislators said, I saw this bill and I thought there's no way we need this since we already dealt with this back in 2019. And then I read the Shorter Arms case and realized, we do need Senate Bill 94 to fix it, because the court is clearly interpreting and applying this in a way that most of the legislators who worked on the 2019 bill did not intend. We also, made sure to create flowcharts and graphics and create comparison tables and really try to help visualize the changes in the process and how the warranty of habitability worked. And then a lot of in-person meetings to walk through the bill. We heard several times from legislators say, going into a committee hearing or something, or going into meetings or negotiations, they would say, this is the most prepared I've ever been on a bill, because you guys have just provided so much material, so many explanations in all these different ways, so many different charts and flow charts and graphics. And so I was very proud that our team was able to do that, because it really prepared the advocates to be able to push for the bill in the legislature. And then, of course, including compelling tenant stories. Mr. Anderson of the Anderson versus Shorter Arms case came and fought for this bill very hard. And having him there to tell his story and to talk about the horrible conditions that he lived in, and then how the warranty of habitability statute failed him in his efforts to try to get justice, was a huge factor in moving the dial and getting some legislators on board. And then, like I said, some of our biggest challenges were, wasn't this fixed in 2019? And Anderson versus Shorter Arms was kind of the big piece that we were able to point to say, actually, no, it didn't fix it. There were all these unintended consequences, and that's why we need this bill. And then there was also the concern of, won't this hurt mom and pop landlords, which is always a concern that everyone takes very seriously. No one wants to hurt a small time landlord who's just doing the best job that they can. And so we were able to make some, very carefully crafted, negotiations to compromise on some of the more, more heavier burdens that the statute may place on on landlords, so that it would make it a little bit easier for mom and pop landlords to continue operating. Next slide, please. So this is just generally how it now works in Colorado. If a landlord has any written notice from anyone about an uninhabitable condition, the landlord must act. And so the any written notice means even if it's the landlord's own notes that they took, or the maintenance person's own notes that they took, if that provides the landlord or anyone who works for the landlord notice that there's some problem in the tenant's unit. It also can include code enforcement coming out and issuing a report, or a neighbor saying, hey, the whole 8th floor is flooding. Then everyone on the 8th floor has now been deemed to have given notice to the landlord. Because it's just this common sense, like if the landlord knows about it, the landlord knows about it. And we shouldn't have some sort of technical loophole where they can jump and say, oh, but this tenant didn't give me a specific piece of paper that said something about it. That doesn't matter. It should just be that the landlord knows about it and is obligated to act. And so that notice can come from anyone. And then the landlord has to communicate to the tenants about their intent to start repairs and give an expected timeline within 24 hours. They then have to start repairs within 24 hours for emergency conditions and 72 hours for non-emergency conditions. And some examples of what those emergency conditions or non-emergency conditions are listed in the statute. And then there's a presumptive timeline to complete repairs, which is 7 days for emergency conditions and 14 days for non-emergency conditions. And again, it's on the landlord to explain and show, if this were to end up in court, why the landlord didn't meet these presumptive timelines. And then if a tenant requests and it's an emergency condition, then the landlord has to provide a hotel or alternative unit during repairs. Next slide, please. The last thing that I'll mention is that Senate Bill 94 also has inspired some local action. This is a new Denver ordinance that came out and was enacted just in recent weeks, where the Denver Health Department can now require landlords to relocate tenants when their homes are uninhabitable. What Denver was seeing is that they would send out code enforcement, or they would send out the health department and find all of these, terrible conditions in tenants' homes, and they would impose fines and fees on the landlord. And the landlord would often think, well, not every landlord, but some landlords would think, well, if these fines or fees are less than the cost of doing the repair, and so I'll just pay the fines and fees, or I'll just kind of wait until the Denver tries to enforce it and take me to court. And if it's just a few fines and fees, Denver's going to be too busy. Their attorneys are going to be too busy to actually enforce it and take them to court. And so Denver decided to pass a new ordinance saying that they can require landlords to relocate tenants when their homes are uninhabitable. And if landlords don't provide this relocation assistance, then the new law lets the health department to place a lien on the property. And if the city then has to pay for the accommodation themselves, then they can place a lien on the property to cover the cost plus 5%. And so this is a nice middle ground for a local ordinance where, as I said, Denver kind of only had the option of fines and fees, or they could condemn the whole building, which would result in the tenants all just losing their home. And Denver was very reluctant to do that unless it was really necessary to protect the tenants. But now this kind of gives a nice middle ground where instead of having to condemn the building, the Denver can just order the landlord to provide a relocation and alternative place for the tenants to live while the place is being repaired. And so we're very excited that Senate Bill 94 kind of inspired that local action. This is the city council members pointed to Senate Bill 94 as an example of how this was in line with sort of the mission of Senate Bill 94. And so we're excited to see that, and we hope that more localities in Colorado take up similar ordinances as well. Next slide, please. That's all. There's my thank you, everyone. I think we're going to save questions until the end, but there's my name and email address if anyone wants to reach out, ask any questions, or chat about anything that I talked about today.
Thanks so much, Spencer. And thanks for highlighting how important it is for legal service providers to provide feedback and insight onto how laws can be strengthened. There are some questions for you in the chat if you would like to answer them as we turn it over to our next panelist. But thank you so much again, Spencer. And I will now turn it over to Monique to talk about New Orleans Healthy Homes Ordinance. So Monique, I'll pass it over to you.
Great, thanks so much. Thanks for having me today. My name is Monique Blossom. I'm the Director of Policy at the Louisiana Fair Housing Action Center. We are a civil rights nonprofit that's 30 years old, dedicated to ending housing discrimination and segregation and enforcing the Fair Housing Act of 1968. And so today we'll be talking about New Orleans Healthy Homes Program, sort of from advocacy to implementation. Next slide, please. So what I'd like to cover with y'all today is briefly go over the problem, some details of the ordinance that was passed in 2022, talk about our advocacy efforts, and then wrap up with discussion of implementation and some challenges that we've faced. Next slide. So to start the problem, this comes from a screenshot from our Healthy Homes Coalition website. Rents keep going up, but tenants aren't getting what they pay for. Thousands of New Orleanians live in unsafe and unhealthy homes. Leaks, mold, and fire hazards threaten residents' health, lower school performance, and weaken our neighborhoods. Slumlords are profiting off of our lax health and safety protections. City leaders need to come together and address the problem of unsafe and substandard rental homes. So with our messaging, we wanted to focus especially on the social determinants of health that unhealthy housing have, as well as identifying the bad guy in the situation, which are slumlords. In New Orleans, unfortunately, we have a number of notorious slumlords and properties, and we worked closely with a lot of tenants who unfortunately had to live in those properties. And so, like Spencer had mentioned, taking the pressure off the mom and pop landlords, that of course, if they're doing everything right, being part of the Healthy Homes program wouldn't be a punishment, but really targeting the bad actors that we see in our communities. The other part of the problem here in New Orleans, and I know Andronika is going to speak to this at length next, but we have a very old and aging housing stock that also is made worse by the extreme heat and humidity that is natural to New Orleans already, but getting worse with climate change. We're also seeing stronger and more frequent hurricanes, as well as stronger daily thunderstorms that are causing street flooding, more flooding in homes. So next slide. So just a couple of examples here. On the left, we have a mold-ridden apartment that was in the Oakmont, owned by a notorious slumlord, Josh Bruno. We're happy that those apartments are permanently closed, but somebody was living in there, even though it does look abandoned. And then to the right, this is a smaller unit. I mean, not a multifamily property, a small landlord. This tenant had complained about the ceilings leaking and sagging. The landlord never repaired, and then along came Hurricane Ida in 2021, and from the amount of rain and the holes in the roof and the ceiling, the full ceiling collapsed, ruining all of her belongings and, putting the tenant in a situation to find a new place to live right after a hurricane, which I know you can all imagine is very difficult and stressful. Next slide, please. So the ordinance in November of 2022, the New Orleans City Council passed an ordinance creating the city's Healthy Home Program to ensure safe and habitable dwellings by requiring registration of rental property or a rental registry, health and safety standards for all residential rentals, renter anti-retaliation protections, as well as an anti-displacement fund. Next slide. To start with the registry, all landlords must apply, and they don't have to pay a fee for a certificate of compliance with the city's Department of Safety and Permits. Landlords then self-certify that rental units meet the health and safety standards that are required of them. We advocated and wrote the ordinance that these would be proactive inspections. And that large landlords that have buildings with hundreds of units wouldn't be able to self-certify, and that would be just reserved to the mom and pop. But as I'll go into detail later, sometimes the ordinance you write isn't the one that gets passed. The certificates of compliance must be renewed biannually. Landlords can face late fees if they're not registering on time. And of course, that certificate of compliance can be revoked for repeated violations or if the unit poses health or safety risks. Next slide, please. The health and safety standards are minimum habitability standards that include safe and operable plumbing, electric systems, smoke alarms, and heating and cooling systems. We did get a provision that requires air conditioning. We're happy about that, but it's not quite strong enough to guarantee the relief everyone deserves in the middle of a hot Louisiana summer. So it requires in bedrooms that air conditioners safely maintain a maximum temperature of 80 degrees. We believe this gives tenants a fighting chance on getting window units replaced in bedrooms. 80 degrees is really not that cool at the end of the day and is difficult to sleep in. And so we hope that we're able in time to strengthen that, but we were glad it's included. The other health and safety standards, roofs and windows free of leaks and mold, no rodent infestations, well-maintained mechanical and cooking appliances, as well as a carbon monoxide detector is now required. Next slide, please. The anti-retaliation protections, tenants have a right to report violations of the law or the property code without fear of retaliation from their landlord. And I have that in quotes because there are exceptions that we'll go into in a minute. Protected activities for tenants include notifying the landlord of violations, requesting repairs, reporting issues to authorities or the public, so they're able to report concerns to the Healthy Homes program and make complaints without worrying about retaliation, as well as providing testimony in legal proceedings. Next slide, please. Prohibited actions by landlords include terminating the lease, increasing rent, decreasing services, threatening legal action, or refusing to renew a lease. And if these actions occur within 6 months of a tenant making a complaint, it is assumed that the landlord has retaliated. Next slide, please. And so here are the exceptions that the first one is really problematic for me. And again, this isn't what we advocated for, it's what City Council passed, but a tenant is not protected from retaliation if they're behind on their rent. We hope in time that we're able to strengthen this and get rid of that, but we all know that some of the lowest income members of our community are living in the worst conditions, and they may fear eviction or simply just be stuck in unhealthy and unsafe housing. The tenant's also not protected if they complain about an issue that is beyond the scope of the standards, if the tenant, family, or guest damages the unit on purpose or threatens the safety of others, or if the tenant has violated the lease agreement in any other way. And so I will add, here at the Louisiana Fair Housing Action Center, we have cost-free eviction defense services, and we have been able to use the anti-retaliation protection to prevent an eviction. That we did have a client who requested a repair and the landlord proceeded to attempt to evict them. So we do know that it's working in local eviction court, but of course we want to strengthen this as we're able over time. Next slide. And lastly, the anti-displacement fund was created by the ordinance. The intended use of these funds would be if, as a result of the Healthy Homes programs, inspections, and needed repairs, tenants are displaced, there would be money available for hotels storing their personal items, first and last month's rent, if they need to find a new apartment. But as of now, no money has been allocated to the fund, though it is desperately needed. And we work with a budget coalition at the city level and continue to ask for several $1 million a year into this fund, but haven't been successful yet in our advocacy there. Next slide, please. So to speak to our advocacy, I'll start by saying this push to get this ordinance passed took 10 years. I came in about a year and a couple of months before the ordinance was finally passed. So I'll mostly be speaking to my work going into the final passage. But we created a Healthy Homes Coalition. Next slide, please. We created a Healthy Homes Coalition that grew over the decade it took to include over 65 organizations. And we have housing, health groups, criminal justice reform, housing providers, good government, a dance nonprofit, cultural groups, labor groups, really the full community of nonprofits here in the city of New Orleans. We were also sure to center renters with lived experience in our advocacy effort because unfortunately, unhabitable conditions are not rare. Most renters have some sort of experience with them here in New Orleans. Next slide, please. And leading up to the committee hearing for the Healthy Homes Ordinance, I said that I'd attend the opening of an envelope if I heard about it, any chance to get in front of renters, landlords, and community members who are impacted by unhealthy housing. We went to full staff meetings for coalition members, their member meetings in the evening. We really put in months of work to try to be everywhere at once, speaking to folks about this. We also coordinated our own phone banks and had an email action alert. And what our main goal was to make it as easy as possible to take action. So at events, our handouts would include QR codes that if you don't know what council district you were in, you just had to scan to do that. Scripts for talking to city council staff, as well as a QR code that linked to our website that had all of the phone numbers, and you could just click the button and your phone would say, "Want me to call this number?" And you said yes. To make it as easy as possible, since making a phone call is becoming more and more terrifying every day for folks to take that action. We also worked with community members on testimony prep and provided gas, travel, and parking compensation for renters that were able to attend the city council committee hearing. And our goal was hundreds and hundreds of calls and emails. And fortunately, we were able to do that and show this full city council that this idea isn't coming from some policy nerds at a fair housing center, but that this is what the community needs for their own health and safety. Next slide, please. This is just an example of one flyer we brought to one event. You can go forward. Maybe we're glitching. But you can see that we had several things for people, several examples for people to pull out if they didn't have a personal experience that they wanted to share. Next slide. And then lastly, implementation and challenges. The final extended deadline for certification of compliance registration is June 15th. So we're very excited that that day is finally here. The program began in full in January of 2024, and the director of the program wasn't able to begin working until the end of February. So we're about a year and some change into establishing the program and implementation. With implementation, we phased in who will register when, and the first to register were the larger buildings with more units, because we know that, apologies for the typo there, the bad actors are mostly going to be found with those larger buildings. And there have been several extensions and delays, including the change to biannual renewal to keep up with the administrative challenges. Next slide, please. I got some quick statistics from the director yesterday on implementation that 39,000 units are registered and fully in compliance. They're working through a backlog of several thousand with issues that need to be resolved. And of the 78,000 potential rental units in the city, they're in contact with about 2/3 of owners in the first cycle of registration. Next slide, please. So some of the we have a lot to celebrate. I mentioned some changes I would like to see to the policy, maybe down the road with a different city council. But some of the challenges we faced was the political will. This took 10 years to get passed. They would get a city council member's support, and it would get too close to an election for them to be willing to run this ordinance, and we'd have to wait. As I mentioned, the ordinance that you write isn't the ordinance that you necessarily get. We unfortunately, in the final amendments and negotiations, were not part of the conversation. We had advocated for mandatory proactive inspections instead of with the self-certification just for the small landlords. But what the council passed instead puts the onus on renters to make complaints to get an inspection, which even with the anti-retaliation protections makes them vulnerable, especially if they're behind on rent. Next slide. So please stay in touch. I'll try to answer questions in the chat. I'll stick around for the Q&A at the end. And thank you so much for having me.
Wonderful. Thanks so much, Monique. So to wrap up our New Orleans case study, I will now pass it over to Andreanika. And Andreanika does not have any slides, so please take it away. Oh, and you're on mute.
I'm muted. Sorry. Thank you. Thank you. Thank you.
Happens to me all of the time, in the worst times.
Yes. And then I do have slides. I didn't get a chance to get them to you, but I do have slides.
Oh,
Is that okay?
perfect.
Can I share
And
my
you
screen?
have the ability to share your screen.
Yes.
So take it away.
All right. All right. Give us 1 second here. I'm talking to the universe. Afternoon, everybody.
And as you're pulling that up, Andreanika, I just want to flag for our presenters that there are some questions coming through the chat if you wanted to respond to them. maybe the Q&A might be an easier place to put your questions in, just because there's a lot of activity going on in the chat. But if not, we will share our contact information out at the end so that you're able to reach out to us. And I will pass it back to you, Andrea.
Sure. Thank you so much. Appreciate you, Netta, and to be on this panel with everybody. Really grateful, especially with our partners at the National Income Housing Coalition, as well as our partners at Louisiana Fair Housing Action Center. As Netta said, I'm Andrea Morris, and I wear several hats, and I lead what we call the Put Housing First Triad here in Louisiana that's working to end housing insecurity in Louisiana with three organizations, the HousingNOLA, the Greater New Orleans Housing Alliance, and Housing Louisiana. And I'm preaching to the choir here when we say, but it's important to say because have a pretty provocative name when we say put housing first in order to put people first. As Netta said earlier, housing is central to opportunity. And we know that in order to get to a just society, we must first and foremost guarantee housing for all, and no matter what's going on. And there's also the rampant discrimination that finds its place inside of housing, and particularly in places like New Orleans and Louisiana, where the vestiges of slavery still are pretty significant. Of course, that's not just a Louisiana problem; it's an American problem. But we are also, in a lot of different ways, for a lot of different reasons, prepared to deal with those challenges than a lot of other communities, and have been making progress and strides. And the Healthy Homes Initiative, the Healthy Homes Ordinance, has come out of a lot of work that's been pushed on for a number of years. You heard Monique talk about this current iteration took about 10 years from the first introduction and those initial meetings and all of the different things that happened to finally implementation 2 years ago. But there was also conversation before that introduction about doing something, a rental registry, about expanding Section 8 standards to all renters, and they have been shot down. And part of it is our leaders refuse to accept responsibility for housing security, the whole concept. Instead, they continue to kind of cling to this notion about what affordable housing means and what about programs and how they marginalize and frankly ghettoize those various programs. They don't think about housing as a collective. And the best example that we have of this is the words of a particular landlord leader inside of this market. Donald Valley, who is the president of the Section 8 Landlord Committee. Yes, we actually have a landlord committee that seeks to rival from a power perspective the roles and responsibility that tenant leaders have inside of our housing authority framework. Donald Valley said from and he was also a member of our Louisiana Housing Corporation board of directors. The Louisiana Housing Corporation is our state's version of a housing finance agency. They administer LIHEAP dollars, as well as other federal funds that come through the state, and the low-income housing tax credits. And Donald Valley said from that day, there's no way to define affordable housing. We know that that's not true, right? All of you on this call know that that's not true. We know that cost burden is a calculation, and we live by those numbers because it's necessary for people. In order to make sure that people have enough, they need to be able to have housing that is under that number. And in Louisiana, the rent is too damn high because people don't make enough money, and our housing costs are out of control. This stage has been set by Hurricane Katrina, and it's also the source of a North Star, if you will, to talk about how we rebuild. I do not like to, and I resist the urge that a lot of our leaders use to call Katrina an opportunity and subsequent disasters an opportunity. It's not an opportunity because people died. And it should be a call to action. And particularly when you note that we spent about $50 billion in the 10 years after Katrina investing in bringing back over 100,000 housing opportunities between doubling the amount of our vouchers, rebuilding public housing, and bringing online new homes and apartments that were renovated or completely built from the ground up in the 10 years afterwards, but we still didn't have enough housing, right? There was still not enough housing. And after those 10 years, we found a serious misalignment in the market where you had home values had skyrocketed, rents had skyrocketed, wages, when you adjust for inflation, had not actually gone up in the 10 years after Katrina. And so we started with our HousingNOLA 10-year plan, which was launched 10 years ago this year in 2015. And the current state of housing is we are looking to implement and intercede, but we still need more to do. Wages and rents have gone up, wages have gone up modestly, but not enough to keep pace with the home value issues that we see. And this has been over the time that we've been tracking this over the last 10 years. We have got and actually things have gotten worse in a lot of ways. The demand model shows that for renters and homeowners, it's particularly dire at the low end of the spectrum, but it's also a problem for working class folks, and we're squeezing people in the proverbial middle. And so we've been pivoting to a housing for all action plan that would talk about centering the needs of folks and making sure that when we put things forward, policies forward, that we're making the proper investments in those policies to stand them up, but also making sure we're putting the right policies in place in the first place. And the Healthy Homes Initiative fits right in with our desire to ensure a more resilient housing stock and system, right? We want to be able to, when something happens, and it doesn't have to just be a hurricane, it doesn't have to be, we don't have to just talk about some of our climate realities as if they're inevitable. We need to be talking about everyday crises that people are facing and renters are facing disproportionately. And part of the reason they're facing that is because they're living in housing that is simply spoken substandard. When you look at the overall needs, where we need to construct new and we need to help homeowners, you also see that we need to fully weatherize and rehab over 58,000 homes and apartments. And that drives pieces like the Healthy Homes, so that when we talk about putting slumlords out of business, we are also talking about supporting good landlords who need access to capital in order to provide safe, decent homes for the renters who they are serving, and they need the ability to do that. It can't simply be a gotcha. Which again, but we do have to stand firm on standards. We have to make sure that those standards are achievable, because we don't want to let particularly slumlords and predators off with they can't do anything about it. They can't figure out how to raise these resources. No one's making this money available, and this would cost another $31 billion. Obviously, there's concerns and questions about where those dollars would come from, but we've got to put the guardrails in. And again, that's where policies like the Healthy Home Strategy, Healthy Homes Ordinance come into play and are significant drivers of exactly those kinds of investments. You can talk to lenders about making sure that people's investments are going to be protected, because the investments next door and frankly the people next door will not be left to their own devices, and that the government will be supporting these qualitative standards. So we're talking about significant investments, and we're talking about making sure that homes are energy efficient. That's another big issue. Like, we can talk about, when we talk about the needs of renters, we have to talk about them being able to pay their rent and utilities. And if they're living in a home that is not quite substandard, but not in great shape. We have a lot of people who are energy cost burden across the state, who are energy cost burden because of their utilities. And they're living in modest homes that are not in great shape, but are not in terrible shape. And that can't be something, again, that we allow, to take place because number one, those homes are going to easily deteriorate. Given the climate realities, they will deteriorate. And so we've been talking about the policy piece, and there's been some policy victories in the last few years. And that includes things that also help support the Healthy Homes Ordinance, like a $2 million that has been awarded annually for the last 3 years for right to counsel, so that tenants actually have protection when the worst should happen and they are facing eviction. And or they have to leave if there's if there's tension and issues and challenges, that they have support through our local fair housing and legal rights entity organizations. They get resources from the city of New Orleans to stand up a right to counsel program. And also we heard from previous on in Denver and in talking about what's going on in Louisiana. We also have been able to do a significant rehab of our code, of our building code. That has been a long fight. After Katrina, I think a lot of you probably work with developers and builders, as well as other advocates. And there's no fight quite like the fight with talking to builders about having better building standards. And 15 years ago, some of the most bitter fights that we had were with our local home builders association about increasing the code, about improving the code, the building code. And now, because this issue is so obvious and so straightforward, they are some of the biggest champions of better building codes, and better building codes that center the occupants, right? We have one of the strongest energy conservation codes in the deep South, in the South, in Louisiana. That's Louisiana leading on something and getting support from the builders, because there's finally an understanding and a recognition of this, that homes need to be healthy in order for them to be homes. And so we've also talked about getting the resources together. So we have a housing trust fund that was passed last year that dedicates 2% of our operating cost, our general revenue, in perpetuity. And that was won by a 50-point margin. And when you talk about, and it's also necessary because when you look at the investments that are being made, the public investments, we are not seeing the resources that we already have being managed particularly effectively. And the transparent process that is going to be a part of that trust fund is going to help illuminate a lot of that. We also have, and part of the reason we're looking at this is we want to make sure that there's more capital floating around, that people actually have more money to build wealth and power in New Orleans, first and foremost, and then moving on to the challenges across Louisiana. Because one of New Orleans' biggest problems is that it's in the state of Louisiana. We have been worried for the last couple of years, as we've been standing up the rental registry, the Healthy Homes Ordinance, about state preemption. And what we should be looking at, and we are looking at, is state replication. We have at least two other municipalities, Monroe and Lafayette, that are looking at their own healthy homes. They're starting very modestly with healthy homes dollars that they're getting from the federal government that's prioritizing lead paint and other healthy and green priorities. But we want them to get to the place where they are looking at rental registries across the state. And there's been significant pushback around that, because for a number of reasons. That pushback has been kind of blunted because of the insurance crisis. We also have an insurance crisis happening. Louisiana has some of the least affordable homeowners insurance, and we always want to make sure that people understand that while the property insurance that most homeowners have is also a problem for small mom and pop landlords and large scale landlords. This is not something that's just isolated. And we always want to be careful about the language that we're using to make sure that renters understand, especially renters who are living in owner occupied units, how this is impacting them and how it's driving, and how it has been driving for the last few years, significant increases in rents. and also not making it feasible to affect large scale construction and building of new homes and rental homes and apartments. But it's also making it tough to allocate dollars for rehabs and rehabilitation and basic maintenance, right? People's operating costs are going up. They don't have enough money to put to the side to affect basic repairs. Guess who pays for that in more ways than one? Renters. And this is, of course, a result of climate change issues. And as you'll see with this map, while the issues are worse in the coastal areas, it's not just the bottom half of the state that's struggling with this. So, oops. Sorry, this changed a little bit. We want to talk about our priorities, and we actually had a 2025 legislative kill list. We had several anti-homelessness legislations, things that would criminalize homelessness and also make it harder to get people into healthy homes, right? We need to see better investment inside of our communities. And oops, sorry, I was not supposed to end that there. We need to see better investments inside of our communities, and we're not seeing that. And I will say, wait, hold on a second. I'm sorry. The slideshow stopped. Sorry. Okay, gotcha. Sorry about that, y'all. Some technical pieces that we got to bring home, and I'm almost done. That was the really funny part. I think the timer thought I was finished. Oh wait, gotta go back. Okay, so we got our kill list, and then we've got the federal foolishness, as we call this. We've also got to be paying attention to things that we're worried about. When we talk about, again, healthy homes, energy efficiency, air quality, those are also big parts of it. It's also an opportunity. This is actually an opportunity to divert other resources or smartly allocate resources that would help us improve housing stock and housing quality. The low-income housing energy efficiency program I mentioned earlier, we have the best energy conservation codes in the Deep South, in the Gulf South, sorry. Those dollars could have been used to help landlords and small mom and pop landlords to make those investments in their properties as well, and to help them lower their rents and to make sure that their tenants had lower utility bills. And what's happening with the federal foolishness that we're dealing with is that program has been zeroed out, and the federal government is entertaining dismantling FEMA in the middle of as hurricane season has just started. So that means that we need to be talking about insurance to make sure that people actually can have insurance to pay for it. And not only if the worst should happen, but to make sure that they can maintain their homes when everyday small level crises happen. And everything from, a tree falling over on your neighbor's property or into your property. We actually had a partner, kid you not, a car ran into their home. So there's everyday challenges in a place like New Orleans, and we need to make sure that we're getting that our legislators are not simply we're not simply stopping them from doing bad things. We've got to get them to do good things. And with that, we had bill priorities that some of them passed. And it included things that have been typically pretty problematic for low-income folks, like some better transparency around credit, and that impacts renters and homeowners when they're trying to get insurance either for their car or their property. And we want to see that change. And we've been doing a lot of research to make sure that we can do people-centered voter engagement to get people engaged with their elected officials, because at the end of the day, we need our leaders to respond to their constituents. And that is always a balancing act when it comes to the needs of renters. And the Healthy Homes Ordinance is a really great way to defang some of the anti-NIMBY or the NIMBY nonsense that we get out of homeowners who are concerned about what's going on in their neighborhood, and it just becomes easier to demonize renters. We've always talked about with the Healthy Homes Ordinance is that we need to be putting the responsibility on the people who are responsible. That's the property owner, and that's something that most people agree on. And that the property owner is responsible, but somehow we have deteriorated this into a place where not only does the renter have to bear the burden of living in a slum or a substandard home, they also are responsible for that condition by their mere existence. And so we have to talk about voter education, voter engagement, so that people are passing and enacting policies like the Healthy Homes Ordinance and actually fully realizing it. One of the big challenges that we have from a legislative standpoint in recent years is that we've seen bills passed that would, rather than walking down the full line of healthy homes and shut down bad businesses, bad landlords, and relocate people, right? Monique talked about some of the great things inside of the ordinance as it exists. One of the challenges that we have is that relocation fund that has been in existence has never been capitalized. And we actually have a piece of legislation that was passed a few years ago designed to put pressure on a large scale development, and the Healthy Homes Ordinance actually moving through that process at the same time to inspect and to listen and respond to complaints with that large scale developer. And they come a little short because they don't have money to relocate the last of the folks who have been there as they've been shutting things down. They want to relocate people, but they don't have the resources to do so. And that is one of the things that we have to do. We have to make sure these things are in alignment. The investments are aligned with the policy, because if we displace everyone that makes New Orleans cool, will they still think it's cool? And that the answer to that is no, because we can't replace what we displace. And that's it.
What a perfect way to end this call. Thank you so much to our presenters today for joining us. And thank you all in the audience for joining us as well. I will share out our contact information through connection and memo on Monday. But in the interest of time, I will end the call here with a note that I hope you all enjoy the rest of your week. And thank you again for joining us. And please feel free to reach out if you have any questions. And we'll see you all very soon. Thanks, everyone.